Have you been arrested for a DUI offense? If so, you may have experienced one of the most stressful events of your life, being arrested. You probably have many questions about what will happen, what penalties may be imposed, and what steps should be taken to ensure that you are treated fairly. You may even be wondering if you really need an attorney. Perhaps you're thinking that you can simply go to court and deal with the problem yourself. Unfortunately, DUI is a serious criminal offense which will pit you against the power and resources of the state. The district attorney is not your friend. Their job is to prosecute you and maximize the penalties. And because no politician wants to appear soft on drunk drivers, the severity of the penalties has increased year after year. A person found guilty of even a first-time DUI offense can expect a period of informal probation, significant fines, license suspension, compulsory attendance at an alcohol education program, and either community service, house arrest, or jail time. In fact, in some jurisdictions, it is more and more common for even first offenders to serve some jail time. Penalties usually increase substantially for repeat DUI offenses or in cases where the driver is involved in an accident that causes injury or death. If you are unrepresented by an attorney, you will likely not get a chance to present your case in an effective manner. At your arraignment, the judge will ask if you wish to plead guilty or not guilty. If you plead guilty, you will be sentenced immediately without the opportunity to present evidence or to minimize the penalties that could be imposed. But it is important to remember that just because you have been arrested, it does not mean that you are guilty. Improper testing procedures, certain health conditions, and errors on the part of the arresting officer can all produce inaccurate results. As your attorney, we will present your case to the court in the most favorable light. Depending on the circumstances of your case, we will challenge the initial traffic stop to help ensure that the officer had the necessary probable cause to make the stop in the first place. We will ensure that the proper testing procedures were followed, as any deviation from the proper protocols can induce significant errors to the test results. If there was a significant period of time between when you were driving and when the blood alcohol test was done, other critical defenses might exist, including a rising blood alcohol level due to absorption after the stop. Our strategy is to make the prosecution prove every element of the case against you and to seek dismissal of the charges against you if an error has been made or there is insufficient evidence to support a conviction. DUI defense is a complicated process, and you have a great deal at stake. You face the possibility of jail time and significant fines, as well as other serious penalties that could significantly impact your life. You need an attorney who is familiar with the court system and the legal process and understands the defenses that are available to help you mitigate the penalties that could be imposed by the court. Contact our office today to discuss your case. Let us help protect your rights and your driving privileges.